Hello everyone, welcome to my Indian Corporate Law lecture series. I hope you remember our previous classes and company meetings where we have studied various categories of meeting. So today we are going to learn essentials of a valid meeting, or what are the requirements to be fulfilled to be consider a meeting as valid. ಒಂದು ಮೀಟಿಂಗ್ಸ್ಗಳನ್ನ ನಾವು ವ್ಯಾಲಿಡ್ ಅಂತ ಹೇಳಿ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕಾದ್ರೆ ಯಾವೆಲ್ಲ ಫಾರ್ಮಾಲಿಟೀಸ್ಗಳನ್ನ ಫಾಲೋ ಮಾಡಬೇಕಾಗ್ತದೆ ಕಂಪನೀಸ್ಗಳಲ್ಲಿ, ಯಾವೆಲ್ಲ ರೂಲ್ಸ್ಗಳನ್ನ ಫಾಲೋ ಮಾಡಬೇಕಾಗ್ತದೆ. ಸೊ ದ್ಯಾಟ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಲರ್ನ್ ಇನ್ ಟುಡೇಸ್ ಕ್ಲಾಸ್. Of course, there are all a list of requirements for a valid meeting. So just uh, go through one by one. After that, we are going to learn in detail. Proper authority to convene a meeting. So it indicates who is the responsible person to call a meeting. Proper and adequate notice of meeting. So a notice should be circulated among the members regarding meeting. So this will state how a notice should be and among whom the notice should be circulated. All these things will be covered here. Content of notice. So, what are the requirements or what are the things that should be mentioned in a notice that will be covered here under section 96 and subsection 2? And who will be the chairman of meeting, or who is going to handle the entire meeting, who is the head of meeting, that will be considered here. Quorum of the meeting. So here quorum represents the minimum number of members should attend the meeting. That will be discussed under section 103. And here proxies. So proxies, that indicates the authorized person appointed by the members. The rules regarding this appointment of proxies and the rights of proxies, that we are going to discuss. And the seventh point regarding agenda of the meeting. So this agenda represents the things are going to be which are going to be discussed in a meeting. Motions, so that represents uh, uh, the things which are going to be discussed, of course, in a meeting and which should be moved by the members. Methods of voting. Of course, there are plenty of methods for voting in a company meetings. So we are going to discuss the various types of voting which are acceptable. Resolutions. So there are various categories of resolutions and there are various requirements for the specified resolutions. So that we are going to discuss. And the 11th one, minutes of meeting. So that represents the final outcome of the meeting, which is in the written form. So in written form of the meeting's outcome or the meeting's decision. So we are going to discuss regarding that also. And fine. So here it is the index for the today's class. We are going to discuss all these points in detail. So let me start with the first one, the proper authority to convene meeting. So that represents who is the responsible person to call the meeting. ಒಂದು ಮೀಟಿಂಗ್ ಅನ್ನು ಆರ್ಗನೈಸ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಯಾರು ಮೀಟಿಂಗ್ ಅನ್ನು ಕರೀಲಿಕ್ಕೆ ಅಥಾರಿಟಿ ಇರ್ತದೆ, ಸೊ ದ್ಯಾಟ್ ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಹಿಯರ್. ಇಫ್ ಇಟ್ ಈಸ್ ದ ಬೋರ್ಡ್ ಆಫ್ ಡೈರೆಕ್ಟರ್ಸ್ ಮೀಟಿಂಗ್, if it is the general meeting, board of directors has to call the meeting. And if it is extraordinary meeting, then any shareholders can request the board of directors to call for a meeting. And if it is the special case, in that case tribunal or the court can call for meeting and under the uh, requirements or based on the petition of the members or the directors. So either the members or the directors can request the tribunal to call for a meeting. So these three are the special situation. You should remember, if it is a general meeting, Board of directors can call a meeting. If it is extraordinary meeting, shareholders can request the board of directors to call for a meeting. And in a special situations, either the member or the director can request the tribunal to call a meeting. And the second point is proper and adequate notice of the meeting. So, regarding the notice to be circulated among the members regarding meeting. ಮೀಟಿಂಗ್ಸಿನ ಬಗ್ಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ಸ್ ಅನ್ನ ಮತ್ತು ಇನ್ವಿಟೇಷನ್ಸ್ ಅನ್ನ ಮೆಂಬರ್ಸ್ಗಳಿಗೆ ಕಳಿಸಿಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ಕೆಲವೊಂದಿಷ್ಟು ರೂಲ್ಸ್ಗಳಿದೆ. ಸೊ ಇನ್ ದ್ಯಾಟ್ ದ ಜನರಲ್ ರೂಲ್ಸ್ ರಿಗಾರ್ಡಿಂಗ್ ನೋಟಿಸ್. ಸೊ ಹಿಯರ್ any responsible form, any reasonable form, any reasonable form. So this notice should mention the date, time and place of meeting, and which should be attached with the agenda. Agenda means specifying the reason for the meeting, why they are called the meeting, and which should be served in the manner as specified in articles of association. So the notice or the rules regarding notice may be different from companies to company, and they should follow the rules as specified in articles of association. Of course, the common rules of articles of association or companies act. According to this, 21 clear days for general meeting and 14 days for private company. If it is a public company, 21 clear days of notice should be served among the members, and if it is for the private company, 14 clear days of notice should be served, and which should be sent to. ಯಾರಿಗೆಲ್ಲ ಈ ನೋಟಿಸ್ ಅನ್ನು ಕಳಿಸಿಕೊಡ್ಬೇಕಾಗ್ತದೆ. So here you can identify every member of the company and legal representative of a deceased member, if any, the auditors of the company, every directors of the company. For all these persons, notice should be served. ನಮ್ಮ ಮೀಟಿಂಗ್ಸ್ ಆಗುವ ಮೊದಲು 21 ದಿನ ಅಥವಾ 14 ದಿನದ ನೋಟಿಸ್ಗಳನ್ನ ಈ ಎಲ್ಲ ಪಾರ್ಟೀಸ್ಗಳಿಗೆ ಕಳಿಸಿಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಸೊ ದ್ಯಾಟ್ is the requirement regarding notice. And the third one, content of the notice. So what are the things that should be covered in notice? ಸೊ ನನ್ನ ನೋಟಿಸ್ನ ಒಳಗಡೆ ಯಾವ ಇನ್ಫಾರ್ಮೇಶನ್ಸ್ ಅನ್ನಗಳನ್ನ ಹೇಳಬೇಕಾಗ್ತದೆ. ಸೊ ಇಫ್ ಇಟ್ ಈಸ್ ಫಾರ್ AGM or annual general meeting, you know that AGM is conducted for the normal routine purpose. So for that, this notice should contain the similar aspect: audited financial statements, directors or auditors report, proxy forms, attendance slips. So all these things should be covered for AGM along with the notice. And if it is for AGM, extraordinary general meeting, so this notice should be attached with extraordinary statements. So this extraordinary statement should have to explain the purpose of extraordinary general meeting. ಎಕ್ಸ್ಟ್ರಾರ್ಡಿನರಿ ಜನರಲ್ ಮೀಟಿಂಗಿನ ಯಾವ ಸ್ಪೆಷಲ್ ಪರ್ಪಸ್ಗೋಸ್ಕರ ಕಾಲ್ ಮಾಡಿದ್ದೇವೆ, ದ್ಯಾಟ್ ಶುಡ್ ಸ್ಪೆಸಿಫೈ ಹಿಯರ್. And proxy form, attendance slip, of course, as in case of AGM. Proxy form ಮತ್ತು attendance slip ಇದರ ಬಗ್ಗೆ ನಾವು ಇನ್ನೂ ಕೂಡ ಡೀಟೇಲ್ಸ್ ಆಗಿ ನೋಡ್ಲಿಕ್ಕಿದ್ದೇವೆ. So these things should be attached with the notice. And the fourth one, chairman of the meeting. So here chairman represents the leader of the meeting. So here who has to be the chairman of a meeting? ಯಾರನ್ನ ನಾವು chairman ಆಗಿ ಅಪಾಯಿಂಟ್ ಮಾಡಬಹುದು? So here the person who preside over the meetings, usually the member. So ಕಂಪನಿ ಮೀಟಿಂಗ್ಸ್ಗಳಲ್ಲಿ ಯಾವುದೇ ಕಂಪನಿಯ ಮೆಂಬರ್ಸ್ ಅನ್ನ ನಾವು ಚೇರ್ಮನ್ ಅಂತ ಹೇಳಿ ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು. ಬಟ್ ಯೂಶುವಲಿ for first chairman, which should be mentioned in articles of association. ಕಂಪನಿಯ ಇನ್ಕಾರ್ಪೊರೇಷನ್ ಆದ ನಂತರ ಫಸ್ಟ್ ಮೀಟಿಂಗ್ಸ್ಗಳು ಆಗಿದ್ರೆ, ಸೊ ಫಾರ್ ದ್ಯಾಟ್ ಫಸ್ಟ್ ಚೇರ್ಮನ್ ಅನ್ನು ಅಪಾಯಿಂಟ್ ಮಾಡುವಂಥದ್ದನ್ನ ಆರ್ಟಿಕಲ್ಸ್ ಆಫ್ ಅಸೋಸಿಯೇಷನ್ಸ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿರ್ತೇವೆ. ಅಂಡ್ ಫಾರ್ ದ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಚೇರ್ ಪರ್ಸನ್, board of directors will decide after AGM. So this chairman will have to handle the entire meeting process. So here we have listed the various powers and duties of chairman. Of course, it's similar to the leader of any meeting. He has to maintain order and decorum, give ruling on the points of order, maintain relevance and order in the debate. So anything uh, uh, which covers or which plays the role of any meeting, leader of any meeting. So he can adjourn the meeting and he can exercise casting vote. So his vote will decide the meeting. That means if for any subject, if the votes taken or votes came in equal manner, in that situation, he can vote. The chairman can vote. If it is the balancing situation. And his duties, of course, must act honestly and must ensure all the legal aspects of the meeting and must give proper chance to every member who are present, must preserve the order in a meeting, and must ensure that all the members get equal chances. So, of course, the chairman of the meeting has some powers as well as the duties. The fifth one, quorum of the meeting. The term quorum represents the minimum number of members required to be present in a meeting as specified by law. ಸೊ ಒಂದು ಮೀಟಿಂಗ್ ಅನ್ನು ಕರೆಯುವಾಗ ಆ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಕನಿಷ್ಠ ಪಕ್ಷ ಎಷ್ಟು ಮೆಂಬರ್ಸ್ ಇರಬೇಕು ಅಂತ ಹೇಳಿ ನಾವು ಡಿಸೈಡ್ ಮಾಡ್ತೇವೆ ದಟ್ ಈಸ್ ಕನ್ಸಿಡರ್ಡ್ ಆಸ್ ಕೋರಮ್. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ನಿಮ್ಮ ಕ್ಲಾಸಲ್ಲಿ ನಿಮ್ಮ ಕ್ಲಾಸನ್ನು ತಗೊಳ್ಳಿಕ್ಕೆ ಮಿನಿಮಮ್ ಇಷ್ಟು ಮಂದಿ ಇರಬೇಕು ಅಂತ ನಾವು ಡಿಸೈಡ್ ಮಾಡಿದ್ರೆ ಸೊ ದ್ಯಾಟ್ ಈಸ್ ಕನ್ಸಿಡರ್ಡ್ ಆಸ್ ಅ ಕೋರಮ್. So here it's differ from companies to company. That means based on the category of company. For public company, the quorum is 5 if the members are below 1000. If the total number of members is below 1000, quorum is 5. So our company total number of members 1000 in the 5000 ಒಳಗಡೆ ಇದ್ರೆ quorum is 15. At least 15% ಇರಲೇಬೇಕಾಗ್ತದೆ ಮೀಟಿಂಗ್ ಅನ್ನು ಕಂಡಕ್ಟ್ ಮಾಡಲಿಕ್ಕೆ. If the number of members is more than 5000, the minimum number of persons should be 30. So it's regarding public company. But as far as private company, it's different. So in case of private company, quorum is 2 members. At any cost, there should be 2 members for a meeting and they have to present personally. ಅವರು personally present ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ they can continue with the meeting. So if any meeting fails to prove the quorum ಅನ್ನು ಪ್ರೂವ್ ಮಾಡಲಿಲ್ಲ, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಪಬ್ಲಿಕ್ ಕಂಪನಿ ಟೋಟಲ್ ಮೆಂಬರ್ಸ್ ಇರುವಂಥದ್ದು 1000 ಮೆಂಬರ್ಸ್. ಸೊ ಅಲ್ಲಿ 5 ಮೆಂಬರ್ಸ್ ಇರಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಮಿನಿಮಮ್ ಅಂತ ಮೀಟಿಂಗ್ಸ್ಗಳನ್ನು ಅಪ್ರೂವ್ ಮಾಡಲಿಕ್ಕೆ ಬರುವುದಿಲ್ಲ. ಸೊ ದೇ ಹ್ಯಾವ್ ಟು ಅಡ್ಜಾರ್ನ್ ದ ಮೀಟಿಂಗ್, ದೇ ಹ್ಯಾವ್ ಟು ಕನ್ಕ್ಲೂಡ್ ದ ಮೀಟಿಂಗ್, ದೇ ಹ್ಯಾವ್ ಟು ಕ್ಯಾನ್ಸಲ್ ದ ಮೀಟಿಂಗ್. So here there are some restrictions or rules regarding this quorum. So in that, consider only the members who are personally present. So personally present ಇದ್ದಂಥ ಮೆಂಬರ್ಸ್ಗಳನ್ನು ಮಾತ್ರ quorumಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗ್ತದೆ. Quorum to be present at the beginning of the meeting. For example, ಮೀಟಿಂಗ್ ಅನ್ನು ಸ್ಟಾರ್ಟ್ ಮಾಡುವಾಗ ಇಬ್ಬರಿದ್ರು, ಮೀಟಿಂಗ್ ಅನ್ನು ಎಂಡ್ ಮಾಡುವಾಗ 5 ಮೆಂಬರ್ಸ್ ಇದ್ದಾರೆ. ಸೊ ಅಂಥ ಸಿಚುವೇಶನ್ಸ್ ಅಲ್ಲಿ ಕೋರಮ್ ಅನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಮಿನಿಮಮ್ ನಂಬರ್ ಆಫ್ ಮೆಂಬರ್ಸ್ ಶುಡ್ ಬಿ ಪ್ರೆಸೆಂಟ್ ಅಟ್ ದ ಬಿಗಿನಿಂಗ್ ಆಫ್ ದ ಮೀಟಿಂಗ್. ಎನಿ ರೆಸಲ್ಯೂಷನ್ಸ್ ಪಾಸ್ಡ್ ವಿತೌಟ್ ಕೋರಮ್ ಇಸ್ ಇನ್ವ್ಯಾಲಿಡ್. 2 ಮೆಂಬರ್ಸ್ ಇದ್ದಾರೆ, ಮೀಟಿಂಗ್ಸ್ ಅನ್ನು ಪಾಸ್ ಮಾಡಿದರೆ, ರೆಸಲ್ಯೂಷನ್ಸ್ ಆಗಿದೆ, ಬಟ್ ಸಚ್ ರೆಸಲ್ಯೂಷನ್ಸ್ cannot be considered as valid. Consider only the shareholders who have voting rights. So some shareholders ಇದ್ದಾರೆ, ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರೆ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ, ಬಟ್ ಅವರಿಗೆ voting rights ಇಲ್ಲ. So we cannot consider them for quorum. Joint owners are considered as single owners. We cannot consider separately, so we have to consider them for a single person. Consider the member company representatives for quorum. So member company representatives that can be considered for quorum. where the total number of members reduced below the quorum, it's invalid to apply quorum. So if the total number of members, for example, in case of private company, total number of members is below 2. So in such situation, there will not be any question of quorum. So quorum of the meeting, of course, if there is no quorum, then what is the next process recording meeting? Within quorum, half an hour of meeting, quorum should be proved. So at the beginning of the meeting, quorum should be proved. So within first half an hour of meeting, there should be quorum. They have to take the attendance and they have to satisfy that the quorum is present and they can continue with the meeting. Meeting shall be adjourned to the same day of next week if the quorum is not there. So for example, quorum is 5, but number of members present was 3. So quorum is not there for the meeting. So they have to postpone the meeting. So in such situation, the meeting shall be adjourned. That means postponed to the same day of next week. So if the meeting day was a Friday, the meeting will be postponed to the Friday next week. Even though quorum is not there in the next week also, the members present shall be the quorum. So next week Friday, again only 3 members are there. Again the quorum is not there. But even then the members present shall be the quorum. So even then the 3 members can be considered as a quorum. ಅಲ್ಲಿ ಇರುವಂತ 3 members quorum ಇಲ್ಲ of course, but still ಅವರನ್ನೇ ಪ್ರೆಸೆಂಟ್ ಇರುವ 3 members ಅನ್ನೇ quorum ಅಂತ ಹೇಳಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೇವೆ. ಮಿನಿಮಮ್ ನಂಬರ್ ಆಫ್ ಮೆಂಬರ್ಸ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ ನಮ್ಮ ಮೀಟಿಂಗ್ಸ್ಗಳನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗ್ತದೆ. Normally, single person cannot be a proxy for many. ಸೊ ನಾರ್ಮಲ್ ಸಿಚುವೇಶನ್ ಸಿಂಗಲ್ ಪರ್ಸನ್ ಅನ್ನು ನಾವು ಒಂದಕ್ಕಿಂತ ಹೆಚ್ಚು ಜನರಿಗೆ ಪ್ರಾಕ್ಸಿ ಆಗಿ ಕನ್ಸಿಡರ್ ಮಾಡಲಿಕ್ಕೆ ಬರುವುದಿಲ್ಲ. ಸೊ ರಿಗಾರ್ಡಿಂಗ್ ದಿಸ್ ಪ್ರಾಕ್ಸಿ ಆಫ್ ಕೋರ್ಸ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಲರ್ನ್ ಇನ್ ಡೀಟೇಲ್ ಇನ್ ದ ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್ಸ್. ಸೊ ಹಿಯರ್ ಪ್ರಾಕ್ಸೀಸ್. The term proxy refers to a person who is authorized by a member of a company to attend and vote at a meeting of a company on his behalf. So here, a member of the company will appoint some other person to represent him in the meeting. For example, ನಿಮ್ಮ ಕ್ಲಾಸ್ಗಳನ್ನು ತಗೊಳ್ಳೋದಾದ್ರೆ ನಿಮ್ಮ ಕ್ಲಾಸಲ್ಲಿ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಚೇತನ್ ಕೆನಾಟ್ ಅಟೆಂಡ್ ದ ಕ್ಲಾಸಸ್. ಸೊ ಹಾಗಾಗಿ ಚೇತನ್ ಪರವಾಗಿ ಅವರು ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವರ ಬ್ರದರ್ ಅನ್ನು. ಸೊ ಚೇತನ್ಸ್ ಬ್ರದರ್ ವಿಲ್ ಅಟೆಂಡ್ ದ ಕ್ಲಾಸ್. ಸೊ ಅಂತ ಸಿಚುವೇಶನ್ಸ್ ಅಲ್ಲಿ ಚೇತನ್ ಬ್ರದರ್ ಏನಿದ್ದಾರೆ ಅವರನ್ನು ನಾವು ಪ್ರಾಕ್ಸಿ ಅಂತ ಹೇಳಿ ಕರಿತೇವೆ. ಸೊ ಹಿಯರ್ a person who is authorized by a member or appointed by a member of a company to attend and vote at a meeting of a company on his behalf. ಅವರ ಪರವಾಗಿ ಆ ಮೆಂಬರಿನ ಪರವಾಗಿ ಇನ್ನೊಬ್ಬ ಪರ್ಸನ್ ಅಪಾಯಿಂಟೆಡ್ ಪರ್ಸನ್ ಆ ಮೀಟಿಂಗ್ಸ್ಗಳನ್ನು ಅಟೆಂಡ್ ಮಾಡಲಿಕ್ಕೆ ಮತ್ತು ವೋಟ್ ಮಾಡಲಿಕ್ಕೆ ಅವಕಾಶ ಇರ್ತದೆ. ಸೊ ಅಂಥ ಪರ್ಸನ್ಸ್ಗಳನ್ನ ನಾವು ಪ್ರಾಕ್ಸಿ ಅಂತ ಹೇಳಿ ಕರಿತೇವೆ. Of course, there are various legal rules regarding the appointment of these proxies. The first one, a member can appoint more than one proxies for the same meeting. For example, I can't attend the meeting and of course I am the member of a company. So what I can do is I can appoint another person or I can appoint more than one person for such meeting. I can appoint Mr. A and Mr. B for the same meeting. So here minor cannot be appointed as proxies. So ಯಾವುದೇ minor ಅನ್ನ proxy ಅಂತ ಹೇಳಿ ಅಪಾಯಿಂಟ್ ಮಾಡಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. Only the major can be appointed as a proxies. A person cannot represent more than 50 members. For example, I cannot be a proxy for more than 50 members. ಸೊ ಮೋರ್ ದ್ಯಾನ್ 50 ಮೆಂಬರ್ಸ್ಗೆ ನಾನು ಒಬ್ಬಳೇ ಪ್ರಾಕ್ಸಿ ಆಗಿ ಯಾವುದೇ ಕಂಪನಿ ಮೀಟಿಂಗ್ಸ್ಗಳನ್ನ ಅಟೆಂಡ್ ಆಗಲಿಕ್ಕೆ ಬರುವುದಿಲ್ಲ. Appointment must be in writing and should be signed by the member. Of course, there is a separate format, form number MGT.11. So this is the appointment form for appointing proxies. Deposit of document of an of appointment to the company before the commencement of meeting. So before commencing meeting, member has to communicate this appointment to the company. Usually before 48 hours of such meeting, they have to communicate. Valid for adjournment of a meeting. For example, I have appointed a proxy Mr. A to the for some meeting on Friday of this week, but on that day the meeting was adjourned. Meeting was postponed to next Friday. So same proxy can attend the meeting on the next or the future date of such meeting. May or may not be the member of company. Of course, this proxy may be the member or may not be the member. That will not be a matter. A right to vote but not right to speak in a meeting. So such proxies cannot speak in a meeting but they can vote in the meeting. Notice of meeting should state whether proxy is allowed or not. So the notice which is circulated from the company among the members, that itself should have to state whether proxies are allowed to such meetings or not. Only if it is allowed, then the members can appoint the proxies, otherwise not. Members' right to inspect the proxy regarding the voting. So ಅಪಾಯಿಂಟ್ ಮಾಡಿರುವಂತ ಮೆಂಬರ್ಸ್ ಪ್ರಾಕ್ಸಿ ಯಾವ ಪರ್ಪಸ್ಗೆ ವೋಟ್ ಅನ್ನ ಮಾಡಿದ್ದಾರೆ, ಅವರ ವೋಟಿಂಗ್ಸಿನ ರಿಸಲ್ಟ್ಸ್ ಏನು, ಸೊ ದ್ಯಾಟ್ ಕ್ಯಾನ್ ಬಿ ಇನ್ಸ್ಪೆಕ್ಟೆಡ್ ಬೈ ದ ಮೆಂಬರ್ಸ್. Revocation of proxies that can be done at any time, usually before voting. Members of a company not having share capital are not entitled to appoint the proxies. So these person cannot appoint proxies. So these are all the legal rules regarding proxy appointment as well as the removal. The next one, agenda of the meeting. So as the name indicates, agenda. So that is refers to the things to be done in relation to the meetings of a company. The list of items to be discussed or transacted in a meeting. So this represents the basic purpose for which they have called for a meeting. Generally prepared by the company secretary in consultation with the chairman. Agenda should be prepared well in advance and should be circulated among uh, uh, the members along with the notice of meeting. It should be prepared well in advance and should be circulated among the members along with the notice. While sending the notice itself, they have to send the agenda, because based on the agenda, the members can decide whether to participate in a meeting or not. And the next one regarding motions. So here it refers to definite proposal placed before the meeting for discussion. So it's related to agenda, but of course agenda will be prepared well in advance, but this motions represents of course the subject or the proposal or the plans which is placed in the meeting. The meeting ಅಲ್ಲಿ ಒಂದು ಸಬ್ಜೆಕ್ಟ್ಸ್ ಅನ್ನ ಏನು ಪ್ರಪೋಸಲ್ಸ್ಗಳನ್ನ ಪ್ಲಾನ್ಸ್ಗಳನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ. ಸೊ ದ್ಯಾಟ್ ಪ್ಲಾನ್ಸ್ ಆರ್ ದ ಪ್ರಪೋಸಲ್ಸ್ ಕನ್ಸಿಡರ್ಡ್ ಆಸ್ ದ motions. The member presenting the motion is called the mover and he should put his signature. So ಯಾರು ಈ ಪ್ರಪೋಸಲ್ಸ್ಗಳನ್ನ ಪ್ಲಾನ್ಸ್ಗಳನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ, ಸೊ ದ್ಯಾಟ್ ಪರ್ಸನ್ ಈಸ್ ಕಾಲ್ಡ್ ದ ಮೂವರ್ and he should put his signature for proposal. A motion when passed with or without amendment is called resolution. ಸೊ ಆ ಪ್ಲಾನ್ಸ್ಗಳನ್ನು ಅಪ್ರೂವ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಸೊ ದಟ್ ಆಫ್ಟರ್ ಸಚ್ ಅಪ್ರೂವಲ್, ಸೊ ದಿಸ್ ಮೋಷನ್ ಇಸ್ ಕಾಲ್ಡ್ ಆಸ್ ರೆಸಲ್ಯೂಷನ್. Of course, recording resolutions and categories of resolutions that we are going to discuss in detail. Before that, so here voting. So for the motions, they should consider the approval of the members. So this approval procedure are, is considered as voting. Voting is to ascertain the sense of meeting. So ಅಲ್ಲಿರುವಂಥ ಮೆಂಬರ್ಸ್ಗಳು ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಪ್ರಪೋಸಲ್ಸ್ಗಳನ್ನ ಮೋಷನ್ಸ್ಗಳನ್ನು ಐದರ್ ದೆ ಕ್ಯಾನ್ ಅಪ್ರೂವ್ ಆರ್ ದೆ ಕ್ಯಾನ್ ಡಿಸ್ಅಪ್ರೂವ್ ಸಚ್ ಮೋಷನ್ಸ್. ಸೊ ಅಂಥ ಅಪ್ರೂವಲ್ಸ್ಗಳನ್ನು ನಾವಿಲ್ಲಿ ವೋಟಿಂಗ್ಸ್ ಮೂಲಕ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೇವೆ. ಸೊ ಹಿಯರ್ there are various categories of voting. Of course, you know very well recording these categories of voting. So I'll just list out these votings methods. So the first one, of course, you can recognize here by raising their hands, they can put voting for the proposal, or by poll methods, they can provide the votings. So here by secret ballot papers they can vote, and here of course by divisions. So if the members approval is like yes, so they can come to one portion, and if it is no, the members can grouped in another side. So by dividing the total members, so they can consider voting. And of course by putting yes or no by electronic media, they can conduct the voting, electronic voting. And of course by postal ballot papers they can consider the voting. Of course by voice method, yes or no, they can consider the voting. And by voting by colored checks, so if the member shown the yellow colored checks, it's considered as yes, and if they shown the red color checks, it's considered as no. So they can consider any of these voting methods. All these voting methods are valid. And here the next thing is resolution. So we have already considered if the motion is paused in the meeting, so then it's considered as resolution. It is recommended decision of meeting. It is the recommended decision. So after the motion is approved by the meeting, it's considered as resolution. When a motion is passed with required majority in the company meeting, it's called resolution. In other words, it's the formal decision of meeting. So here, these resolutions may be either of these three formats. It can be ordinary resolution, or it can be special resolution, or it can be resolution requiring special notice. So it will be considered ordinary resolution if it requires simple majority. So here simple majority means 51% voting. So total members ಅಲ್ಲಿ 51% ಆಫ್ ವೋಟಿಂಗ್ಸ್ಗಳನ್ನ ತೆಗೆದುಕೊಂಡು ನಾವು ಮೋಷನ್ಸ್ ಅನ್ನ ಅಪ್ರೂವ್ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿ ಅಂದ್ರೆ, ಸೊ ದಟ್ ಈಸ್ ಕನ್ಸಿಡರ್ಡ್ ಆಸ್ ಆರ್ಡಿನರಿ ರೆಸಲ್ಯೂಷನ್. ಫಾರ್ ಸಿಂಪಲ್ ಆಸ್ಪೆಕ್ಟ್ಸ್, ಸಿಂಪಲ್ ಆರ್ಡಿನರಿ ರುಟೀನ್ ಇರುವಂತ ಆಸ್ಪೆಕ್ಟ್ಸ್ಗಳಿಗೆ ಆರ್ಡಿನರಿ ರೆಸಲ್ಯೂಷನ್ಸ್ಗಳನ್ನ ಪಾಸ್ ಮಾಡ್ತೇವೆ. And the special resolution requires 3/4 of the members voting. So it's for special transactions. And here special resolutions requiring special notice of 14 days. So of course it's nothing but ordinary resolution, but it requires 14 days of advance notice to the members. So ordinary resolutions, but 14 days in a notice and a circulate ಇರಬೇಕಾಗ್ತದೆ. So here you can identify the differences between ordinary and special resolution. It represents simple majority, that means 51%, and here it is 3/4 of majority. That is the major difference that you should remember. Notice, no such notice is required. Here must be given to all members. All members should be intimated in advance. Subject matter generally required for ordinary matters, but here it's for special matters. So, which is having permanent importance to the company. It's for routine business. Filling with register of the company need not be filed with the register of the company, but here a very special resolution has to be filed with the register of the company. So in the proceedingsಗಳಿರ್ತದೆ ಮೀಟಿಂಗ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ಡಿನರಿ ರೆಸಲ್ಯೂಷನ್ಸ್ಗಳಾದರೆ ಕಂಪನಿಯ ರಿಜಿಸ್ಟ್ರಾರ್ ಅಲ್ಲಿ ಅದನ್ನು ಪುನಃ ಫೈಲ್ ಮಾಡಬೇಕಾದ ಅವಶ್ಯಕತೆ ಇರೋದಿಲ್ಲ. ಬಟ್ ಸ್ಪೆಷಲ್ ರೆಸಲ್ಯೂಷನ್ಸ್ಗಳಾದರೆ ಡಿಸಿಷನ್ಸ್ಗಳನ್ನು ಫೈಲ್ ಮಾಡಬೇಕಾಗ್ತದೆ. So example you can consider was annual accounts, declaring dividends. So it's the normal things or routine things, or every year they have to pass these kind of uh, resolutions. But here you can consider create reserve capital, change the name of the company, create reserve capital, or uh, increasing the total capitals of the company or changing the capital structure of the company. So these things will have a major impact on the company's performance. So for such decisions, so which requires special resolution. So hope you understood the difference between ordinary and special resolution. And the last one is minutes of meeting. These are the written records of the business transacted and decision arrived at a meeting. So the final outcomes of the meetings in the written forms is considered as minutes of meeting. ಮೀಟಿಂಗ್ಸ್ ಅಲ್ಲಿ ತಗೊಳ್ಳುವಂತಹ ಫೈನಲ್ ಡಿಸಿಷನ್ಸ್ ಏನಿದೆ ಅದು ಯಾವ ರೀತಿಯಾಗಿ ರಿಟರ್ನ್ ಫಾರ್ಮ್ಸ್ ಅಲ್ಲಿ ಇರುವಂತದ್ದಾದ್ರೆ ಅದನ್ನು ನಾವು ಮಿನಿಟ್ಸ್ ಆಫ್ ಮೀಟಿಂಗ್ಸ್ ಅಂತ ಹೇಳಿ ಕರಿತೇವೆ. Of course, there are rules regarding this minutes. The first one, we should be in a written in the book within 30 days of such meeting. So within 30 days of such meeting, the minutes of meetings should be ready. The decisions of the meeting in the written form should be ready within 30 days of such meetings. Pages of minute books must be consecutively numbered. So ಪ್ರತಿ ಮಿನಿಟ್ ಬುಕ್ಸಿನ pages numbers ಅನ್ನು ಹಾಕಬೇಕಾಗ್ತದೆ. So that if anything missed, any one page is missing, they can able to identify the difference. Minute book must be properly signed by the required or authorized person. Fair and correct summary of the proceedings at the meeting. ಮೀಟಿಂಗ್ಸ್ ಅಲ್ಲಿ ಡಿಸಿಷನ್ ತಗೊಳ್ಳುವಂಥದ್ದು ಒಂದು, ಮಿನಿಟ್ ಬುಕ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಆಗುವಂಥದ್ದು ಇನ್ನೊಂದು. ಸೊ ದಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ದೇರ್. ದಟ್ ಶುಡ್ ರಿಫ್ಲೆಕ್ಟ್ ದ ಟ್ರೂ ಅಂಡ್ ಕರೆಕ್ಟ್ ಸಮ್ಮರಿ ಆಫ್ ದ ಮೀಟಿಂಗ್ಸ್. Should include all the appointments made at the meeting and should be kept at the registered office of the company, and it's open to the members for inspection. Any member can inspect or can ask for minutes book at the company. Penalty to the company rupees 25,000 and to the officer it's 5,000. So if any company fails to follow these rules regarding minute book, so which can be uh, uh, held liable for rupees 25,000, and the officer who is responsible for such minute book preparation will be held liable for 5,000 rupees. So these are all the things that should be considered while conducting any meeting. I hope they are able to answer all the essential requirements of valid meeting. They can recall all the essentials for a valid meeting in detail. you for watching. Take care and happy learning.